All right. Well, hello, everybody, and welcome. Thanks for joining us. My name is Derek Gleason. I'm an analyst at Workshop Digital, and I'm really excited today because we have a trifecta of experts to talk to us about the first surprise of 2021, which was some legislation that is almost passed. In Virginia, it's been passed by the House and the Senate, and it's awaiting some reconciliation, and then we'll go to the governor's office for a signature there. So what we're talking about today is where we know the legislation to be right now, which is what we think is probably 90-something% of the way there. But we're here to basically, both for ourselves and hopefully for you all as well, to provide some guidance, things you can expect. We're going to walk through some of the key points of the legislation, both the specifics and the vagaries. And then we're also going to talk about kind of some practical next steps to help everyone get out ahead of this. Ultimately, as scary as some of this stuff kind of seems when it comes out of nowhere, we're excited that one in Virginia that they're out in front of this because it's ultimately going to be good for consumers. And then as a business owner, it's going to give you a chance really to get ahead of the curve of the momentum that we see, obviously starting in Europe with GDPR. Last year, we had California with their Privacy Act. This kind of trend of these acts coming along, it's just a matter of time. So getting out ahead of it is great news. With that, I am going to stop talking so much because I am here to help give you access to the experts. I am not the expert myself. And so I'm going to have each of them go around, introduce themselves at the same time, give kind of their gut reaction to this legislation to get us kicked off. So given that we're starting with something in the legislature, Chris, I will defer to you, the attorney from Sands Anderson, if you'd like to give yourself a brief introduction, and then I'd love to hear your gut reaction, both from your kind of professional viewpoint and also if you want, being a consumer in Virginia, what you kind of anticipate personally and the impact it might have.
Yeah, thanks, Derek. My name is Chris Jones. I'm an attorney at Sands Anderson. I have a litigation background, and some of that will probably come through as we discuss all this. But the past several years, I've also been increasingly involved in privacy, data privacy, and security issues, and it's been very interesting. And yeah, it's been particularly interesting the past couple of weeks as this bill has kind of been sprung on all of us in a rather surprising fashion. And I think in terms of my gut reaction to the bill, I think one of the most interesting things is that there is a lot of ink in the bill devoted to consumer rights of access and correction to data, more of a consumer rights focus. But then there's a very small piece of real estate, maybe 3 lines in the bill, that talks about a requirement for data controllers. We'll get more into what the definitions are later, but basically a data controller is anybody that sits on a sufficient amount of consumers' data. A requirement that these controllers maintain sufficient administrative, technical, and procedural safeguards for the data that they're sitting on. So essentially, we have 3 lines in this legislation that creates a data security requirement in Virginia that's much more comprehensive than anything that's come before. And I think of everything in this bill, that potentially has one of the larger impacts on how businesses are going to have to operate in the future if they want to do business with Virginia consumers.
That's great. Well, that's a perfect segue, Randy, to you as we go to the data security side of things. So please, a brief introduction and then your gut reaction.
Yeah, definitely. Thank you. So my name is Randy Franklin. I'm a general manager with Terrazzo, which is a company that focuses on software consulting. And I have a significant infrastructure and data security background. I've spent over 20 years helping organizations design and implement secure solutions that help them execute their business while also accomplishing all of the necessary security and privacy obligations that they're beholden to. My reaction to the bill is I think that it's great. I think it's good that we're starting to see more emphasis on the state level to really protect consumer rights and make sure that privacy is taken care of. We can hope that the federal government will come to bear as well over time. But I think that it's certainly timely. I'm very happy to see that Virginia is right on the heels of California with enacting some legislation. I think that that's very progressive of the state, and look forward to helping organizations implement it in a way that helps them, really emphasize that they are advocating and fighting for consumer privacy rights.
Great. Thanks, Randy. And finally, rounding out the panel here, Andrew, also from Workshop, love to get your gut reaction as well.
Sure. Thanks, Derek. I'm Andrew Miller, one of the co-founders here at Workshop Digital and a VP of strategy, which basically means I get to think through large, complex, challenging issues facing our clients and facing our industry and help develop solutions for them. And as the CDPA popped up on our radar as well over the last few weeks, my initial gut reaction was very similar. It's why now and why Virginia? That's one facet to that is, how have we not heard more about this prior to the beginning of this year, and why is it happening now? I think it's actually very timely. I think I'm proud that Virginia is out front on this issue, following closely on California's heels with a Privacy Act. I think it is great for consumers, both as a consumer and as a marketer. So the differentiator for brands and companies going forward is going to be, how do you communicate? How do you message that you're taking your consumers' privacy seriously, so that you can build those relationships built on trust, right? And I think the initial reaction that a lot of companies and marketers are going to have is, here we go again. We've got all these new requirements. There's probably a little bit of a fear factor, more so the stick than the carrot. But we have a big opportunity to differentiate companies and the companies we work with and within a marketing organization to talk to consumers about privacy, meet them where they are, and help them understand, what actually constitutes great privacy, and where they might want to focus their energy on keeping themselves and their own data secure, while holding companies accountable, right? We can't just put all the onus on consumers to walk through their own privacy footprint. So I'm excited to unpack more of that as we get into this talk and going forward.
Yeah, thanks, Andrew. And I think maybe the best way to start thinking about some of the specifics in the legislation is the fact that this is coming on the heels of GDPR, the European data privacy law that took effect a couple of years ago, I think in 2018. And then last year, I'm not sure how many people are aware that California implemented a pretty strict and sweeping data privacy law, and the Virginia law is certainly in the context of that. And at the same time that we know that Virginia is kind of on the forefront of passing this, a lot of other states have similar laws in front of them. And so are there any things, as we talk about kind of things, Chris, you mentioned earlier that maybe stick out to you about the legislation, also for people that maybe are already a little bit familiar with GDPR, or who may be familiar with the California law? Are there any points at which you kind of see either things that really stick out specifically about the Virginia one, or ways in which, if somebody's kind of already brings the experience of having prepared for those other ones, kind of differentiating points that they may want to be aware of?
I think it's a good question. I think the good news for Virginia businesses, or for anybody who needs to comply with the new bill, who has a sufficient number of customers in Virginia, is that if you have already started preparing to, or already in compliance with CCPA, you're in a good position to be in compliance with this new law and with whatever regulations come down the pipeline. The California law is, I think, in some ways slightly more restrictive, actually, than Virginia's. One of the key differences there is that a consumer in California has the option to basically request that the person controlling their data is restricted from processing it in certain ways. And there's some allowance for that in the Virginia law as well, but it's smaller in scope. And the two laws do mirror each other in terms of the fundamental consumer rights that they're creating, which is the right to access your data. That is, to request of a controller, hey, do you have anything of mine? Do you have my personal information? And what are you doing with it? And critically, I think, the right to correct that information if it's found to be inaccurate. Probably the biggest difference between California and Virginia law at this point, then, is with enforcement. And that's the good news for Virginia businesses, is that the enforcement mechanism in Virginia is, I think, significantly more business friendly than it is in California. California has a private right of action, so any consumer, any individual consumer, can themselves bring suit against a controller that has mishandled their data. And you can't do that well, there's no private right of action created by the Virginia statute. To the extent you can locate one somewhere else in the common law, it's there, but it's not spelled out in this statute. Enforcement in the statute is through the Attorney General alone. So essentially, the Attorney General's office will be charged with identifying any missteps and prosecuting those, and then issuing penalties of up to $7,500 per violation. So that's the bad news, is when we're talking about per violation and we're talking about consumers in the hundreds of thousands, that can mount pretty quickly. But you shouldn't get there the way this bill is written. There's a safe harbor provision. Gives you a 30-day, I believe it is, right to cure. So before any action is taken against you by the Attorney General, they're going to say, here's what you're doing wrong, stop it. You've got this amount of time in which to stop it. And only then, if you've not stopped it after that period of time, are you going to be subject to those penalties. So it certainly is something that businesses need to pay attention to. And if you get those letters from the Attorney General's office, you need to read them and, and think about what to do in response to them. But you don't have to worry about an army of aggrieved consumers out there bringing suit against you individually.
And it's probably worth just re-mentioning again that even if this gets signed within the next month, none of these provisions are going to be taking place until January 1, 2023. So they are giving companies almost a 2-year head start to kind of comply with some of these. Randy, from your perspective of someone who's really close to actually the real data and process of that, when you think of this kind of safe harbor rule, this kind of 30 days to comply, does that seem like it's really something feasible as far as that's correctable, or do you think that's kind of, I guess does that feel like a real provision that's going to be useful to companies that maybe at the transition point may struggle to kind of get it right from the start? Does that feel like a good outlet, and then a place where issues or problems could be correctable before it becomes these kind of 6, 7, 8, 9, 10-figure fines that are kind of hypothetically hanging around out there?
It could be, and it's going to depend on how well the organization understands its process by which it procures, processes, and then ultimately discards the private data that it has on consumers. So I think that what is beholden on businesses right now is to, if they haven't already done the work by being subject to other policies like FERPA or HIP or COPA or some of the other regulations that cover privacy, is to really spend the time working through their business processes where they collect, process, and then ultimately discard or even share or subcontract out the processing of private information of citizens, to make sure that they understand exactly what data they're collecting. Are they collecting just the data that they require? Are they being very clear with themselves and the consumers what they're doing with that data, and then ultimately how they choose to discard that data after that processing is concluded? If you understand that process, even if you see where there are opportunities to improve that, if you do get a letter from the Attorney General, you should be able to fairly quickly assess the issue and prescribe a mitigation that satisfies the Attorney General, I would say. The real danger would be if you're choosing, or if you just haven't done it yet, and especially if you're a very large organization with some very sophisticated processes and lots of subcontractors doing processing on your behalf. It can take a lot of time because you have to wait for a lot of people to respond to you, especially if you're subprocessing some of these data through, let's say, alternate processors in other countries and things of that regard. It should invoke people to really take the time to understand their process and document that process.
And I think that is where we kind of see it as a positive, of where for the first time from a business perspective, you're not just sort of collecting everything you can collect and just put it in a warehouse somewhere, but you're trying to really figure out what is it that I need. And obviously when we start thinking about it from a marketing perspective, Andrew, then it does become the question of like, well, what data do I really need? Which aspects of the data that I have are really, one, critical to being able to market effectively and intelligently to people. And then, at the same time, we also know as marketers, we're often working with lots of different tools that have kind of a range of, anonymous to, anonymous data, maybe through a Google Analytics, but then you also have a CRM like a Salesforce that has, user specific data. So Andrew, from your marketing kind of perspective, where do you see, I guess one, maybe some of the tools that may be most impacted by this, or some of the aspects, and then as people start to try to really think critically about what data they really need, where you see from a marketing perspective the critical bits of data that people would want to really be thoughtful about how they maintain it?
Well, from a marketer's dream scenario perspective, we'd be able to tie sales and revenue and customers' lifetime value back to a website visit or the viewing of an ad or an impression of some sort, or engagement on social media. So in some ways, the law and any efforts towards greater consumer data privacy kind of limits our ability to track on an individual one-to-one basis this customer engaged with your brand in these channels and eventually converted, whether that's in a store or online or through a direct sales channel of some sort. That's the marketer's dream. But in 50 years of gathering more data about marketing, and in the last 10 to 20 years of actually having digital and large amounts of data at scale, nobody's been able to crack that nut consistently and reliably. And even large brands that have lots of resources and are throwing large teams of analysts and data collection mechanisms at this problem have not been able to solve this issue. So I think for anybody concerned that this is going to limit our ability to market better and determine the ROI of our marketing efforts, we have to be realistic about what we're already able to achieve. I think it's going to further push us towards looking at data in aggregate, right? We obviously can't track individual users at scale without running into some of the complex issues around data retention and privacy. So we have to be more creative in gathering the data that we're looking for and then modeling the behaviors with consumers and the interactions they have with our brands to track them through to that eventual purchase. So the subject of tools you mentioned, which is great because that's exactly where I was going to go with this question, is a lot of us as marketers don't have our own in-house, internal systems for tracking website visitors or conversions or sales that happen online or offline. We depend on Google Analytics or Salesforce or HubSpot or any of the other large platforms that do a lot of the processing behind the scenes for us. So in a way, that's a good thing. Those platforms themselves have to become compliant. And about 2-3 years ago, when GDPR was coming into the fore, we had to work with each of those vendors to make sure that the data we were collecting were compliant. They were on the hook for processing and storing that data in a compliant way. So a lot of times we just got notifications that these settings are changing. This data is going to be sunsetted or scrubbed after a certain amount of time, and we have some control over that as well. But ultimately, it's a partnership between a marketing agency, or marketing organization, whether that's in-house or an agency, the business decision leaders, and any technology partners. And we all have to be in agreement that there's enough data coming in that we need to be able to do our jobs. We need to be able to track our performance and our success without running afoul of the laws. So what's the next best situation that we can put ourselves in? Or what's the best data, or what's the best thing we can do with the data we have access to? And in most cases, we're still able to market just fine. We're still able to track performance and outcomes of our marketing efforts using the data that we have and the tools that we're using while still being easily compliant within the privacy laws. So there's no large risk as long as you're partnering with your stakeholders and with your vendors or partners to make sure that everybody's on the same page with what we're gathering, why we're using it, where it's being stored, and making sure everybody up and down the chain is compliant.
And I think that is something that I certainly relate to, Andrew, as far as from a marketing perspective. We see how much data often that companies and clients have that's going unused. So they're in general, if the outcome of this is that, hey, everybody's taking a little bit of time to think about the data they're gathering and what they're really doing with it, there may not be potentially that much of an impact depending on what it is. The other sort of important caveat to this legislation for now, of course, is that it's only applying to companies that collect at least the user data of 100,000 users a year, which is going to exclude a lot of small businesses. My question for you all is, presumably it's not going to be that way forever. Presumably this is to give kind of like a longer lead time again to smaller companies that may not have the resources in-house to kind of manage these things. But is that a number that you imagine will gradually go down over time? And where do you see, again, there's sort of like the enterprise perspective on this, but also a small business perspective. Again, even if it doesn't apply to them right now, are there some of the steps that they could take, should take, that might look a little bit different? What do you all see for that landscape?
If I can jump in, because this kind of meshes nicely with the point I wanted to make regardless, and that is that Randy is absolutely right to identify certain best practices that I think now should apply to even those institutions that are not covered by this legislation. So the idea that you should only be sitting on data that you need. You shouldn't be going through the time and expense of acquiring data that you don't need and that even worse, can subject you ultimately to liability if you lose it in a breach, or you've handled it now improperly pursuant to the statute. What's interesting is that while that has always been a best practice, this law actually makes it a required practice. Subsection 574 requires that controllers limit the acquisition of their data to only what they need to do their business. And I think that's interesting. So to answer then your question, Derek, I think that people who are currently sitting under, businesses that are currently sitting under the threshold of this law should still be looking at its general tenets and exactly the sort of things that Randy was talking about, and saying to themselves, I may not be required to do some of these things, but it is still absolutely a best practice. I still could be subject perhaps to litigation that's grounded in some law outside of the statute if I'm not doing it. Critically, my business reputation is at stake. Nobody wants to have their data breached and stolen, and no company wants to have to send a letter to a customer of theirs that has happened, particularly when the subject of that breach is data that they shouldn't have collected or should have disposed of years ago. So yes, if this law does not apply to you, if you're under the threshold, still be guided by it. And yes, you should also expect that eventually you are going to be under the auspices of a law that has a lower threshold, because that's certainly what's happening here. We have the supranationalist laws in Europe, and now we're having the larger states addressing these issues. We've even got some smaller states. I think Maine and Nevada are passing or working on similar legislation. It's going to trickle down. It absolutely will. And the product might be better by the time it trickles down to you, because there'll have been so many test groups by the time it gets down to smaller businesses. But expect that one day you'll be on the hook for a compliance regimen, and it pays to just get your best practices in order right now.
Yeah, and I think, to your point, Chris, we even see that with California, right? Because right on the heels of enacting CCPA, they came right behind it with CPRA, strengthening that privacy law, kind of lowering some of those thresholds within it to, further enforce compliance and put more power in the hands of the individual consumers. So I totally agree. I do think that the bar will continue to lower, but businesses shouldn't look at this as a burden, an unnecessary burden or an unnecessary compliance requirement, right? Or a burden, if you will. They should really look at it as an opportunity to really showcase that they are advocating on behalf of individual consumers, and that they are, fighting for and standing up for their individual privacy rights, and being assertive in public with how they are protecting individual consumers' rights, and really making it easy for consumers to provide or accommodate these requests for information access, or the right to be forgotten, things of that nature. I mean, these are opportunities to displace you from your competition, because people will always want to favor businesses that have their best interests in mind.
And that's a great point. And I think, Andrew, from again, coming back to the marketing angle on this, there is that terror moment. If you're, a marketer and you work in a company and there is a data breach, and all of a sudden you're basically having to send really bad news to everybody that you work with. But at the same time, especially for companies that are in Virginia that legally might be obligated to get out in front of things now, maybe there is that chance. How would you think about kind of ways to frame this, or ways to use this to your advantage as a way to kind of show that A, you really do care, and B, that you can, kind of publicly let people know what data that you have, so that you're not one of those kind of, scary black boxes of data that people don't know what you have on them?
Yeah, I want to piggyback on Randy's comment. I think companies that lean into this as an opportunity are going to find themselves with a competitive advantage over time, right? And looking at some statistics right now, about 30% of web users, at least on desktop computers, use some sort of ad blocker, right? There's already a movement towards privacy, and at least privacy in terms of stop targeting me with ads based on my browsing behavior and who I am. You're still going to see ads are going to be less relevant. 87% of people say that they are less likely to do business with a company if they don't trust their data practices. Right? That's almost 9 in 10 consumers are willing to switch companies or switch brands or switch providers if they don't feel like their data is safe. The challenge we have as marketers is letting people know that their data is safe, right? And being able to back that up and communicate that and message that. So one of the things that we are advocating for at Workshop Digital, and we've seen be successful with GDPR and CCPA rollouts, is leading with not necessarily as your main benefit statement or your main feature, but certainly featured prominently the fact that we care about your data. You can trust us with your security. Here's everything you'd want to know about our privacy practices, our data security practices, whether that's simply in a privacy policy that's standard and required on websites, or if it's actually something that you build out more content around so people feel like they can trust you. And that's especially important if you're dealing with sensitive information, right? Not just my name and email address, that's sensitive enough. But if you're dealing with phone numbers, health information, payment information, social security numbers, if that's stuff you need to collect to do your job and process that data, there are certainly ways that you can provide those warm, fuzzy feelings without being, overtly so focused on privacy that you're ignoring the other benefits that you're providing your customers. So I think there's a big movement towards privacy in general, whether consumers are out front leading that or whether it's state regulators bringing in legislation to hold companies accountable. I think ultimately there's no way we're going backwards from here, right? So there's no situation that I can foresee where laws like this get rolled back. To Randy's point, they're going to get tightened, they're going to get strengthened, and I think ultimately companies that just willingly resist at that point are just being are being deliberately and intentionally avoiding the situation and doing what they know to be right. And I think consumers will respond. So to get buy-in, we've got to paint the opportunity to say, this is not just a cost of doing business or a burden. It's a way to get some advantage, get first mover advantage if your competitors aren't talking about it, or to build that into your practice and your products so that there's no doubt that you're putting privacy in the forefront.
I think one thing that, oh, sorry.
Go ahead, Randy.
I was going to say, one of the things that we can track is if we go back a few years and look at some of the hurdles that, say, Amazon Web Services and Microsoft Azure had to assuage some of the concerns of enterprises that they were trying to convince those businesses to bring their data to them. Trust us, we have your best interests in mind. And you can look at both of those as good examples. They set up a compliance center on each of their sites. And inside of those compliance centers, they list out all of the frameworks, all of the different obligations that they adhere to, and they freely make it available if they have a SOC 2 Type 2 or some other type of third-party attestation and certification. They make those available on their website. So, to Andrew's point, it's not just them saying, hey, trust us, we're really good at what we do. They're also showcasing, this is our statement, but look at all these other persons and look at the testing and the results that they've provided as well. And now you have the full concert of not only the organization, but all of the third parties that have also witnessed and weighed in on their ability to protect consumer rights as well.
Yeah, I think that what we're all kind of talking about and envisioning here is sort of a new approach to the privacy notice on a site, right? It no longer viewing it as this kind of humdrum legal boilerplate that's just a drop down on some, that resides somewhere on your webpage, but potentially making it a focus of your pitch to existing and potentially new customers, and finding a way to make those privacy notices more engaging and to really not just be kind of setting forth a recitation of the minimal things that you're doing in order to comply with the law, but the way in which what you're doing makes you different and better than your competitors, and really sort of moving this notice from the dusty confines of your website to some place where people will see it and click on it and engage with it.
Yeah, I had this panic moment last night as I was reading through some more materials to prepare for this conversation. I had that oh crap moment. Are we even practicing what we're preaching right now? Right. So I went and I reread, which I've never done. I actually went through and I read our privacy policy on our own website that was probably built years ago, and I was actually proud to see that we're practicing what we preach, and a lot of those things that are now becoming best practices. Disclosing how you're using the data, who you're sharing it with, what it's used for, when you scrub it. And how to opt out, how to request your information, how to get removed from that. Even for a small company like ours, it's not that difficult, right? It doesn't require a lot of automation. It doesn't require expensive tooling behind the scenes or large teams to go in and make this right. It requires just a little bit of attention and caring about the customer to go in and rephrase how you're positioning your privacy structure, right? And it doesn't depend on building in new technology or infrastructure at the small business scale. For large businesses, definitely call Randy. But you need that automation and that systemization on the back end. But for most of us, it's just a matter of doing the right thing, right? Being clear and transparent about what you're trying to accomplish. And I think consumers are going to appreciate that more and more as they catch on to what's going on.
And it probably, I think, Randy, it was great to think about examples of, okay, who's already doing this and where might some of that messaging live as far as cloud platforms that are hosting this stuff, that really the core of their marketing pitch is about how they handle data, that if you just want to go somewhere to sort of have, some language, some copy that you could even take that's going to make sense. We're probably some companies that are based in California that are doing this already, but to think about, people that, businesses that survive solely on warehousing, data that's subject to HIPAA and those kind of things, where that messaging really is critical to their business, that may be a great place to get not just messaging that puts you in compliance, but messaging that really helps you stand out. I want to move in a second to get into kind of the, okay, so now what? Like what I get off, we get off this webinar, like who are we talking to? What are we doing? The one thing I do want to kind of ask you all is, knowing that this is, it's often called sweeping legislation. In this case, we know that it's not actually that many words to cover every edge case, and there are probably some ambiguities left in there. So knowing that even it's not quite passed fully yet as far as signed into law, are there places now where, based on if I'm reading about it or seeing things about it, places that you really feel like some of the things that I would have to do or should be preparing to do are unresolved, and I should just kind of, keep my ear to the ground to see how those things are shaking out, whether it's in changes to the legislation at the last minute or whether it's in, litigation that follows in this kind of 2-year period before things get implemented?
So the big example I would come back to are the administrative, technical, and procedural safeguards that are required in the legislation. And there's absolutely no embellishment whatsoever as to what that means. So that'll be up to the regulators to flush that out. So you should definitely keep an eye on that. And if that is something that you're particularly concerned in, get involved in the comment process. One potential framework you could look at is last year, the Assembly did enact the Insurance Data Security Act, which does have a very comprehensive security regimen, including the establishment of information security programs and what those have to look like, what sort of risk analyses people have to go through. That I would think would offer a lot of guidance as to how the regulators approach the requirements in this bill, but that is speculation.
I think from a marketing perspective, one of the simplest things to do is start to look at the data you have, right? We've talked about that several times, and then mapping out, from point A where we are today and the data that we depend on to run our businesses and market to our customers, to point B, which is January 1st, 2023. If we no longer have access to some of that data, or we have to change how we use that data, building a roadmap to get from here to there, 2 years should be plenty of time, but it goes by quickly, right? Especially if you're talking about changing platforms or changing backend processes and how you use that data. Some of that time could be spent doing the technical implementation. Some of that time can be spent better modeling and planning for how you can use data that we will have access to in the future. And then the what if scenarios beyond 2023, as it does become more restrictive, right? Or tighter in terms of what's allowed and what's not allowed. So from a marketing perspective, a lot of it's just planning and thinking ahead and just thinking through those what if scenarios. I know we don't have as much of a implementation burden so much as on the back end of a technical infrastructure or IT teams are going to be working through. But I also think, to Chris's point, looking at other legislation to figure out where this could go. And this is, again, hypothetical, but you look at some of the requirements of the High Tech Act, a part of HIPAA, that require, very specifically how to notify parties when there are breaches, how the chain of accountability ladders up through different parts of an organization or different relationships with partners and vendors. So if anything, I think it could become more clearly defined, which will help provide some guidance on what we need to do. But there's a lot of unknowns at this point. I think it's just best to prepare for that worst case scenario where we lose access to some of the data we need to do our jobs, and then come up with the next best situation and do the right thing.
Nice. I agree. And I think, to Chris's point earlier is there are some existing frameworks that organizations can look at to try and gauge where they are in their current information security programs. There's ISO 27001, ISO 27018, which focuses more on the cloud side of things. There are also some federal frameworks like from the NIST, from the National Institute of Standards Technology. It's the regulation 800-53. And you can go through some of these cybersecurity framework self-assessments and try to gauge where you are from just a rote security standpoint. But I think further than just understanding where you are in the security journey is having that conversation internally between the distinction of, to understand the distinction between security and privacy. And I think that a lot of organizations sometimes confuse or conflate the two, and they're really quite different. Security is largely concerned with protecting the information assets of a company, and whereas privacy is really focused on the rights of an individual consumer that's not in your organization. And sometimes these are in direct conflict with each other. For example, one of the basic tenets of a security program is to have good backups and to make sure that you have, copies of data. But sometimes those can run directly uh, directly counter to retention policies, right? So if you have a data practice and your privacy attorneys have decided that you should only keep that data for 6 months, but yet your backup schedule retains copies of archives for 2 or 3 years, well, you have two things that they're not aligned with each other. So I think starting to understand where you are in a security journey, and then also really having that conversation internally to really understand security versus privacy and understand where the two help each other and where the two may conflict with each other in your organization. It's more common, I think, than we let on, that sometimes these two, they're very different conversations, and they really do need to come together in organizations, especially as the data volume increases.
I think you've just done my transition for me, Randy, as we start talking about kind of like, okay, now what? Now what are we doing? And I mean, I think I'd love to think the first thing that we can do is start actioning on it, but obviously what we know is, the first thing that we have to start doing is getting buy-in to get the resources, even to take the time to do this stuff. So, from your perspective, do some of these assessments, do they lend themselves to, hey, our team can, a team internally or externally can do an assessment, and the presentation of that then becomes the buy-in for some of these changes? Or is there kind of a step before that where types of conversations or ways to frame it that you feel productive? And right before I hand it back to you, I will say, if anybody at this point has specific questions that have kind of come up, please feel free to drop those in the Q&A. We'll try to save the last 10 minutes when we have all these brains around here to try to answer as many of those as we can for you. So feel to add in the Q&A. But back to you, Randy, as far as both for the assessments, where do those kind of fit in what you would say is kind of the process of actioning on this? And two, are there specific conversations or ways to frame this topic that seem to resonate with people who may not think about this very often?
Yeah, thank you. And I think that this is where I think there's always an advantage to bringing in a third party. I think a third party can oftentimes help you see things that are maybe not visible, can certainly help share some perspectives that may not necessarily be obvious from inside of the organization. Certainly having buy-in from the top. I mean, it has to be acknowledged and valued from the highest levels of the organization, or it's really just not going to succeed. I mean, these programs live and die based on their backing from the highest levels of the organization. So, back to using this legislation as an opportunity to see individual businesses displace and outplace themselves from their competition. I mean, it should be something that's held close at the highest levels of the organization. And then that high level of the organization bringing together people from the security side of the discipline, the privacy side of the discipline, engaging a third party assessor or an auditor to just come in and at least start highlighting, how do you document a privacy assessment? How do you start to lay out your individual processes and business workflows and understand where there may be risk that may not necessarily rise to the occasion of being observed obviously in the organization. These things will all lend themselves to improved processes and improve transparency, and ultimately help the business, really become an example in the consumer's mind that it's very serious about privacy, and that it's willing to do the necessary things to really do what's right by the consumer.
That's great. And Andrew, do you see, I mean, you may be jumping with another point there, but I mean, as far as getting buy-in, do you see there being any anxiety from marketing teams of sort of worrying about losing data or about their abilities? Kind of how would you frame that to also make sure that marketing feels like this is on their team too, and not just another burden or another restriction on their performance that they might be judged against?
Yeah, Randy's experience is the same as ours. It's most times it's not always this black and white, but you either work in a data-centric organization or not, right? Your organization either understands the value and the potential of the data that you have, or you kind of fly by the seat of your pants and you do what's always worked because it's always worked. So for the latter, right, the companies that aren't as focused on using data as an advantage in their marketing or in their operations, I think we run into what we call the HIPPO, right? The highest paid person's opinion acronym. We throw that around a lot around here because ultimately in that situation, that senior stakeholder, that senior executive may have an opinion that's going to rule the day about how this stuff gets implemented or prioritized, and if at all. So if your organization is just not structured culturally around data, it's going to be a harder sell. Within a marketing organization, if you can move past that and you can have objective conversations and make decisions based on what's best for the customer and using the data you have at your disposal, it's going to be a lot easier to lay out the advantages, right? It's not going to be a direct cost benefit analysis within marketing. It's a little bit different. It's about the opportunities that we're going to have to go out and attract and retain customers. So I think there's a good conversation here to be had across all different company types, and figuring out, where does the use of data fall within your company's culture, and that's usually going to be more telling or predictive of the outcome than kind of a whipsaw reaction to, oh crap, there's a new regulation, we've got to really get this thing into motion. You're either going to adopt it or you're going to lag behind.
And Chris, from your perspective, as far as buy-in goes, knowing that a lot of these C-suite people, the hippos in the room, are going to probably be seeing headlines, maybe seeing, ambiguities or things changing rapidly, where would you guide somebody to kind of give them a kind of like North Star of place to access credible information, what to pay attention to, maybe what not to, knowing that there could be some flux? How would you help kind of manage some of those conversations, or even presenting it as, this is what we know now, and maybe we should start actioning on it now, even though it may not affect us? Where do you look at kind of how people should pay attention, and maybe how to make that case, even with ambiguities in the law, or places where smaller companies may not legally be obligated now, but should sort of assume that that's on the way?
Yeah, I think the first step in the process is to see if you do meet the legal threshold. You do want to know whether your obligations are going to be legal in a year, or whether it's simply a matter of best practices. And so you have to get on top of your data, and that gels nicely with what Randy and Andrew are already saying. That is something you should be aware of. Even if you're not a data-centric organization, you should know whether you're processing the data of 100,000 consumers or more in Virginia. If you are not, the good news is you don't have to worry about complying with this bill from a legal standpoint, although again, it does lay out many best practices for you. If you are, or if there's a couple other thresholds as well. If you fall into the threshold, then there's a potential you could take yourself out of it. And I'd have to defer to the technologists on this panel as to how practical this may be. But this law does not apply in most regards to de-identified data. And so it's possible that you may be processing data on 500,000 Virginia consumers, but you can de-identify that and still get value out of it, and not have to incur the costs of compliance with this. But that's the practicality of doing that is beyond me, and that's going to be certainly a case-by-case basis for the organization and what its goals are. So I think that's the first thing, though. You want to see, does this apply to me, and then does it have to apply to me, and then that's how you then make your sale. Your sale is either we better do this, or else we're going to start getting letters from the Attorney General's office, or maybe the slightly harder sale of, we better do this because this really is the best practice in the direction that things are headed in.
And does that, Randy, from your technical perspective, I mean, does that seem like, I mean, potentially knowing that maybe there could be a lot of companies that, don't really need this data, and maybe that is even like an initial step just to sort of give them some clearance to know that they're not going to be, legally, even if they still have best practice steps to take, that legally they'll be in the clear. Does that seem like something that, given the amount of data that we're kind of all imbibing as companies, that we probably may not know exists? Is that sort of a reasonable thing to kind of look at, as well as whether that's to sort of scope the initial ask or to reduce legal liability?
It absolutely does. It's almost to like the image I have in my mind is, if you're trying to measure the level of water in the pool, do you need to know how many individual drops of water there are? And the fact of the matter is that oftentimes you can, you know, back up a little bit, and you maybe don't need to know the address and middle name of every individual person in your data set if you're just trying to draw, gross averages or gross themes across that data set. There are plenty of statistical models to engage with, and this is where you would want to consult with someone who specializes in data privacy and data aggregation practices. But there are certainly some statistical methods that you can apply to appropriately de-identify that data. And certainly if you're looking at things like benchmarking, or if you're trying to draw conclusions on gross large data sets, you may not need the level of individual specificity that you would if you're trying to do like person-to-person comparisons. So I think this is a great place to engage organizations that have strength in data science and statistical methods with data sets, to really understand what is the appropriate level of identification that I need within these individual elements for the conclusions that I'm looking to draw.
And that again sounds like just like a great opportunity to go back and say, we've never really thought about what data we really need, how we really use this data. Now maybe you have that excuse to help get some of that buy-in, to do that. Andrew, did you want to jump in there?
Yeah, I wanted to expand on that point a little bit, because it's a very novel kind of forward-thinking way of figuring out what data do we need in the future and how do we get to that point. And it ties very closely to what Google and increasingly Facebook are doing these days with how they process data, right? For my seat, we rely on Google Analytics, which is a free product. It obviously processes tons of data, and Google is compliant in their platform. But even Google is acknowledging that consumers and browsers are starting to opt out of tracking, right? Apple Safari browser doesn't allow third-party cookies anymore. It's rolling out to iPhones, iOS devices very, very soon. So there's this conundrum in our business of how do you tie marketing performance back to individual users when you can't cookie them, or you can't persist those tracking cookies for a long time. And one of the interesting developments that is going on now behind the scenes is that type of modeling that you're talking about, Randy, where you can take the data sets that you do have and build in some predictive analytics or inferences about, if we know this about this cohort, but we can't track this other cohort, what can we extrapolate about that group, about their behaviors, about how they convert or interact on our website, to kind of fill in those data gaps. And I think we're all going to have to become a little bit more like data scientists to start plugging those holes in our data structures as more and more chunks start getting taken out. And that kind of serves two purposes. One is we don't have as many blind spots, right? We don't have that individual user level tracking going forward. But two, it does anonymize, or it does remove that individual from the tracking chain, right? So we can extrapolate and model the behaviors without having to know who each individual is. So it's a double-edged sword, but that's already a process that's in motion with a lot of the tools that a lot of us are using on a day-to-day basis in our world. So I'm happy to see that you're on the same page.
And so I think right now we actually have a great opportunity with some of these questions that have come in. Thank you all for sending those in, to transition into Q&A that's going to build on this really kind of practical next steps. Chris, for you, I think one clear one here is people really getting understanding of the difference between data controller, data processor. I think especially that could be valuable as far as the legislation continues to roll out, so people understand what those terms mean. So I'd love to get from your perspective, also knowing kind of historically maybe other similar roles, what those specific terms mean to help people interpret those. And then at that point, I'd love to hear from Andrew and Randy, maybe what some examples in our world, in the business world, would be of who might qualify as a controller, processor, some of those specific tools that when people do start to dig in and say, okay, where do I sit in these? How do I make my list of controllers? How do I make my list of processors? What does that look like? But we'll start with you, Chris. That'd be great.
Yeah, I think that is helpful. And the key thing to understand first about the Virginia legislation is these definitions are pretty broad. We should probably understand what we're talking about when we're talking about personal data, because that's the touchstone of all this legislation. Personal data is basically anything from which you can identify a person, with some exceptions, including public information and things like that. So a processor is anybody that is doing something with this personal data, this personal information. And I really do mean anything. I've got the text in front of me here. Processor processing means any operation or set of operations performed whether by manual or automated means on personal data or on sets of personal data, such as collection, use, storage, disclosure, analysis, deletion, or modification. So anything, if it's sitting there, if it's just being stored, it's being processed. So really, it's the real threshold for me is, are we talking about personal data, and then do you have it on 100,000 or more Virginians? Chances are, if you have it, you're going to meet that definition of processing. The controller is somebody who is directing the processing. So in most situations, the controller might be the person who's licensed the data, and then the processor is a vendor who's doing something with it. But I'll defer to Andrew and Randy about real world examples of that relationship.
I think there was a good Q&A that came in, where they quote, so which category does a local company with a CRM and a few digital Facebook campaigns that run lookalike audiences, for example, would fall into? So in that case, the organization that has collected and is sort of orchestrating all of the information is the controller, whereas the CRM in this case may just be the processor, right? So your CRM may be a Marketo, or it could be a Salesforce, or some other sort of engine that you insert data into. So that engine is doing work on your behalf. You're directing that activity. You're telling Marketo to do something, right? So in that case, Marketo would be the processor, and by being the processor, they're also beholden to treat that data with the same level of urgency and right, if you will, that you as the controller are also obligated to by the law. So in that case, I think controller, I think of as the person who is facing the customer, who has in their mind an outcome that they want to achieve. They've collected this data and they have an end in their mind that they want to go for. But in order to achieve that end, they have to employ other people and other things to do the work. And those things are the processors. It's your Marketos, your Salesforces, all of the other systems tools, other third-party data processors that you may employ to help you achieve that end in mind.
Yeah, and I think from a marketing perspective, and this is the CRM and the Facebook campaigns with similar audiences is a very familiar situation for us. We almost, as a marketing agency, and most of us in marketing almost fit the definition of both controller and processor at different times, even with the same data set. So a practical example for us is, a international client that has hundreds of thousands of customers globally will occasionally share subsets of their customer list with us so that we can go target similar customers, or you can re-engage your existing customers. So at one point we're processing that information, we're finding similarities, and we're then taking those lists and uploading them to Facebook or to Google to find lookalike audiences or people that look like their existing customers, so we can reach out to find new folks. That's controlling the information, because then we're pushing it to a platform that's going to then further process it. So I don't know that the requirements necessarily of a controller versus a processor vary that much when it comes down to just making sure that everything you're doing is compliant and you're treating that data respectfully and within within the confines of the law. So there's in my mind, data is data. We've got to protect it. We've got to make sure that when we're done with it, we don't have it on our systems anymore. And so for that reason, we go through and we make sure that we scrub the data after we're done with it out of our systems, just to make sure that we don't need it after that point. It served its purpose. So I think that just kind of gets us to that space where we have good data hygiene.
And I think there's another great question that came in here asking about talking about GDPR and for the opt-in specifically with GDPR, how people that waited late to implement that, it kind of created this really hard speed bump of having to ask people to opt in without really having a chance to kind of make your case first about why you could be trusted with data, why it was useful or beneficial for them to opt in. And so what might that look like, knowing that we have some leeway here, some ideas kind of going forward to kind of smooth that transition, if there are any points. I don't know if based either on the legislation, Chris or Randy, and some specifics about the data that you see, if there's going to be that similar kind of change to basic opt-ins that's going to happen with this, that might create that moment where people worry about all of a sudden half their email list is out the window. I do know that third-party cookies in general, by the time that this goes into effect in 2023, are probably going to be a thing of the past by then. Chrome and Google have already committed to getting rid of those, I believe, within another year or two, and they're already basically just starting right now testing different ways to get those. So the landscape in general could already look pretty different by the time we get there. But if we look at this as a runway now where we still have some third-party cookies, we still don't have implementation of this, how do we smooth that transition so that we don't lose big chunks of our email list, that all of a sudden things that we know work and rely on marketing don't all of a sudden become impossible overnight? And then how do we maybe, this is maybe the kind of a nice outro, like how do we focus now before we have legal obligations to really provide information to our consumers that's going to build that good faith in advance of having to make some changes in what data we really have access to?
Well, this is a critical distinction between the Virginia legislation and GDPR. GDPR, as you point out, it's opt-in. In Virginia, it's opt-out. So it's another way in which the Virginia legislation is somewhat business friendly, and you probably don't have to worry as much about damage to your data sets or the ability to acquire the data on which you rely. And the opt-out only applies to a certain subset of actions under the legislation as well. For instance, you have the ability to opt out of targeted advertising. So I don't expect that the fallout from this will be anything near what companies may have experienced with respect to GDPR.
Go ahead, Randy. Looks like you have
Yeah, I'm thinking. So, the thought that comes to my mind, thank you, Andrew, is to probably start maybe a light education campaign, just beginning to message to the people who you maybe do have data on, that know you have data on them, or your third parties that you process data in conjunction with, and begin to educate them on, where you are in your journey to implement this law, and be transparent and say, we recognize the importance and the impact of this legislation, and we're moving, to be ahead of the curve, and kind of message to your cohorts as you make improvements in better documenting your processes, or maybe just being more transparent about where does the data go, where is the data consumed. Embellishing your privacy policy on your website, maybe making it a little bit more conspicuous how data is collected, and giving people those more visible, cookie consent banners, if you will. And maybe sharing lists of sub-processors, people that you do business on behalf of. Just being more open. I think all consumers appreciate transparency, and certainly all consumers appreciate transparency when it's aimed in the direction of preserving their rights.
Yeah, I think starting that conversation with your customers and prospects as a dialogue more than an afterthought is the right way to go for the future. And by that, I mean, let's say you've got a home mortgage or a car loan or a credit card. Every year they're required by law to send you a privacy statement, right? And it's this 16-page, single space, 10-point font packet of information that I assume, I've never read one, is there to help me understand my rights and their obligations and how they protect my data. But no, I'm never going to read that, right? But if you think about it, more as an opportunity to say, let me design something either visually or that's contextually helpful for people to understand their rights and how we're using their data. and present that in a format that's actually digestible, then I think you're going to have a higher likelihood of building that trust and that relationship with those consumers. And you can still send the 16-page pamphlet as required by law, but there's nothing stopping you from breaking it down into human terms, right? Making it less, less sexy than an IRS form, right? There's got to be some way that we can bridge that gap and say, here's what we're doing, put it out on the table, and if you don't like it, here's what you can do to opt out. And I think we're just missing that human connection when we're talking about the technicalities of data processing and storage and marketing. We're missing the fact that we're talking to people about very, very sensitive issues that we can do a better job laying out that roadmap or that vision of how we can protect them and build that partnership.
Great. Thank you. Well, I hope everybody got a lot of that. I certainly learned a ton of that, and I really appreciate Randy Franklin from Terrazzo, Christopher Jones, Sans Anderson, Andrew, of course, from Workshop, and myself as well. It was great. Look forward, if you have any other questions, I'm sure you know where to find us online. Our data's out there somewhere.